what we're seeking to achieve with this. The first thing which occurred to me is, while this is a women's conference, it's not just leadership of women, it's leadership of both men and women in all aspects of life as we know it, society, government, and business. By participating, I think it means taking into account the input of others, so giving them a vested interest into decision making, and building a consensus to create sustainable change that we wish to see. If you ask me what I'd like to see through participative leadership, that would be women taking their rightful place at the negotiating table, whether by providing input or using the input to make those decisions. To me, it's about whether we want to negotiate to be the women we want to be, and for the men who we want to be our partners. The challenges are dual. It's not just societal perception of what women are and what men are, but also what women's self-perception is of what women are and what women can achieve in this day and age. As a lawyer, to me, law is obviously an obvious tool for social advocacy. It is society's most fundamental framework for understanding, and then the later entrenchment of rights and obligations between different layers of society. I'm just setting out three different examples where the law is a tool. In the political scene, when I worked on the ground in Nepal, post the end of the Maoist insurgency, when they overthrew their king and set up a new republic, I saw the interim government insert quotas for female representation in government in Nepal of 33.3%. On an economic front, we've seen movements, or at least the attempts to introduce movements for the protection of property rights, particularly for the inheritance of land by women after they lose their husband or their father, so that women are not just dependent on their brothers or their husband's family. In the EU especially, you see the right to work and to receive equal pay. This is taken seriously in the EU and in the UK where I'm based, whereby whereby a woman states she has been discriminated unequally because she does the same work and receives the same pay, taken seriously by tribunals, and there has been favorable decisions. On the social front, when I was on the ground in Kenya, I came across human rights organizations who have basically lobbied extensively for the introduction of the Sexual Offences Act in Kenya, voted in 2006, 5 years ago. What the Sexual Offences Act did was it actually codified sexual offences, both against men and women. Previously, it was under the very questionable head of the offences against morality. What it did was that it enlisted these offences, broadened these offences. It included minimum sentencing. It included, it went away, it did away with the need for corroboration for rape, when sometimes the only witness is the victim himself. It took into account the new realities of HIV and AIDS in sentencing. And most importantly, I think, it offered certain protections for survivors and victims of sexual offences in the judicial process, helping to enable the judicial process to be more victim-friendly. Now, I'm well aware of the way we lawyers are like. Many lawyers will overstate the importance of the law. I will not be one of them. Legislation, to me, has always been a top-down approach. At times, it makes important political statements that we need to hear. I think one such example, not quite legislation, but was a speech stated by Hillary Clinton in 1995, talking about women's rights, human rights. Quite an obvious thing, but never stated before. Again, a top-down kind of approach. What this needs to be accompanied by, at all times, political will for effective implementation, such as implementation of the Sexual Offences Act we just saw, and awareness at a grassroots level The human rights organizations I got to know in Kenya did extensive education work of what the Sexual Offences Act was at a grassroots level to both women and men. I think political will for implementation and work at grassroots level is also particularly relevant in human trafficking, a global phenomenon, whereby the laws very often exist to criminalize human trafficking, but there simply is not the enforcement in practice. Now, this is important to me, the education of both genders, not just of women. I like what Marina Mahathir said yesterday about being unable to divorce ourselves as women from the social context and the traditions that we live in. I think this is particularly relevant in places like Asia, where we hold those traditions dear. In relation to this education of both genders, my favorite example is the example of foot binding in China. 1,000-year-old practice is eliminated in the space of one generation. How this was done was that instead of self-congratulatory and using the moral high ground, I think advocates in China at the time used, they were missionaries to begin with, like overseas missionaries. What they used was influential Chinese writers to publicize the cause within the elite, which then spread downwards. They also formed organizations to sort of obtain two pledges from both men and from women. The pledge from women was to not get their children foot bound, and the pledge from men was to marry these women. So what they in fact created was a generation of unbound women and a generation of men who could marry them. The same approach is actually now being touted in Africa in relation to the cause of penal circumcision, and there is a very good organization called Tostan who is using that to start national and grassroots dialogue on the issue. So for me, the challenge for participant leadership in the law is twofold. It comes at a formal, I guess, legislative level, and an informal grassroots level. I would actually argue that in many cases, the informal level needs to come first. By implementing a simple formal piece of legislation, sometimes you can provoke a backlash that has been seen in many African countries, whereby the imposition of criminal penalties for, let's say, something like penal circumcision actually triggers a backlash, sets us back, destroys dialogue. People think that people take a nationalist stance. They think that their local customs are being challenged by us foreign NGOs. We need to learn from those mistakes. Now, I am a banking lawyer by trade. The law, as I see it, is in the commercial context, and I want to sort of flesh that out a bit more. To me, the use of law is not just through the courts and of legislation. In fact, I never wrote in the courts because I support it. To me, the law is a facilitator of commercial deal flow. In the work I see every day, I see it as innovative, fluid. I see it as an enabler. I do a lot of work with an organization called Advocates for International Development, back in London, which seeks to use law as a tool for fighting poverty. I think this comes at a very interesting time for us in human development, whereby there's this sort of new paradigm shift. I think more and more so people are starting to realize that we need to move away from aid and dependency towards investment and partnership. I think there was a really good book by an ex-Goldman Sachs banker about how aid to Africa has actually caused it to fall behind, and what's needed is investment and partnership. The way I see this partnership taking place with the law, the creation of new structures for investment and impact, whether channeled to women directly or indirectly. I have sort of been involved in creating some of these new structures as part of my work. And more importantly, on a larger scale, the transfer of expertise from the private sector to public sector as we make this paradigm shift. Lawyers can use pro bono contributions for training. I mean, it's my belief that NGOs and governments can also benefit from the same efficiency that the private sector has. It should move towards, revenue efficiency. It shouldn't just always think that it's always going to get the funding and the grants that it needs to progress riches money. I wanted to flesh out 4 different examples of how I see law as a tool for sustainable development. Social entrepreneurship and social business have become two of the latest keywords in this trend. In fact, what I do understand is that the Singapore government is trying to make Singapore a place where social capital is congregate and a conducive environment for social business to grow. Social business basically is a new sector of the economy which seeks to use the power of business to solve certain social and environmental issues. In London, we see the B Corporation initiative taking hold. The B Corporation basically is branding for what we call social business. What I've seen developed in this B Corporation initiative is an accompanying legal framework, which differs from the normal company framework that we have right now. What it does is that it institutes mechanisms within the DNA of a company which allows other stakeholder interests, like shareholder interests, to be considered over profit. The right for shareholders to hold directors and employees accountable to this notice. What I also see is the rise of what we call impact investment and social finance. And at the moment, still a trickle, but something which is growing. In London, in Singapore, in other parts of the world, we see the first rise of what we call social stock exchanges. As we speak, the Asia Impact Investment Exchange is being set up in Singapore for launch later in 2012. What a social stock exchange is basically a platform to raise capital, both debt and equity, but instead of just companies as we know them, listed social enterprises. Social enterprises which are very large scale in nature, which want to scale up even further to spread impact. I also see more of what I call social investment funds, so, which basically invest in what they call social enterprises, such as B corporations or otherwise. Microfinance, a word much vilified in recent times. While I think microfinance has been touted as a development solution and has done a great deal of good for empowering women who are the majority recipients of microfinance, in recent times it's received a backlash because it was shown that to treat microfinance as another asset class, to scale it up quickly without taking into account the welfare of the final beneficiary is not necessarily the right path. And the way the law can respond, though cautiously, is through greater consumer education and protection, such that microfinance organizations can't simply, resort to what you would call practices which are undesirable. So like I said, the law needs to be used carefully because sometimes an overzealous administrator, as you've seen in some parts of India, following the backlash, have implemented legislation which in fact makes microfinance basically untenable because if borrowers don't pay back loans, you can't have a sustainable model. Your entire operation collapses. If let's say your government suddenly says don't pay back microfinance organizations because they're bad. Public-private partnerships, something also very interesting to me. As a law firm I work in London, we've established a growing partnership with the government for Rwanda, which is seeking to transition from a civil to common law jurisdiction to increase foreign direct investment flows. We train their judiciary, their civil service, in banking law and other soft skills. I wanted to speak about the law as an individual as well, given that I'm a young female lawyer in the world of banking and finance. There has been a huge influx of women into the legal profession. At a junior level, taking my own cohort, there was, I think, more than 70% of women at a junior level. At the top level, we had something like 10%. Now, we heard the earlier speech today from Ms. Masjid about the need for progression of women for economic competitiveness. I like that a lot because as a business, starting to realize that they need to progress women to be economically competitive. You can't deny half of your workforce and half of your talent pool, the right to progression, or else you as a corporation will suffer. Clients want the best that money can buy, whether you're male or female. It's not that relevant to them. We're starting to see slowly the creation of more conducive conditions, such as flexible working, made possible by technology. For me, I think the greatest challenge of participative leadership is the self-perception, at least in the corporate world. What do we see ourselves as? A lot of women I know see themselves as more than competent lawyers, but they don't necessarily see themselves reaching the top profession for a variety of reasons. We have to respect that choice, but at the same time I feel that step away from the table because of that perceived self-perception, not because they're not good enough, but because they feel that they may need to sacrifice their careers for their families, or, it's that whole multitasking thing back again. Like I said, the challenge of self-perception. Do you see yourself running an organization, or do you see yourself merely as an employee? How this can be achieved through participative leadership is mentoring within and outside of the profession. I see men and women both mentoring younger women. I think it's a responsibility as as a female lawyer to also mentor outside of the profession to improve accessibility to other younger women. We don't necessarily have a culture of that. We may not come naturally in the corporate world, but it's something definitely achievable. It's a transfer of your existing skills. It doesn't require new skills. And finally, just some thoughts I want to leave with you. I had to think about this last night about how participative we want leadership to be, based on the speaker, Dr. Ramsey's comment. She said yesterday she wished women were less participative, and I wish we could just lead. And I like that a lot. When I was looking at the forward of the brochure for this conference, I liked the message that I saw. How that while we women may seem unified in the goals that we seek to achieve, we may not actually be very unified at all in the ways we seek to adopt them. I saw this firsthand on the ground in Nepal as a young woman, whereby the few empowered female leaders were busy fighting among themselves. They could not get over their egos to achieve what they wanted to achieve for all women. So I could not stress more that we need to work together to harness these synergies. The second point, which I've reiterated before, the leadership of both men and women, which means taking input from both men and women, not just women, in creating the society that we'd like to see. The third thing is the disparity between the law as it formally stands, the executive, and how the law is actually implemented, and grassroots, how we view our own rights and obligations. Social advocacy should be encouraged based on a dialogue of mutual respect, changing the shared commitments of the community while taking into account local traditions, just like the foot binding exercise, the example I had shown before. A dialogue of mutual respect between men and women and within the community, so they feel like, they are initiating a change as opposed to someone just imposing and telling them to follow, which cannot be sustainable. And finally, the one thought that I've had as my own career advances is that commercial context can provide women with a unique opportunity in terms of a leading role as opposed to just participatory. Meritocracy, which is the creed which I've been brought up in Singapore, is gender neutral. Enterprises and businesses driven by profit cannot afford to ignore that. I also agree with what Ms. Masjid said before, which was that it cannot be based on quotas, it's based on competency and the value add, which we do have. the talents that women have in the corporate world is undeniable. I see it every day. So I leave you on that note, and that is my hope, that women can have not just a leading, can have a leading role at the negotiation